that has been undertaken throughout the islands to bring a set of proposals to the communities. And we had a set of town hall meetings all around the islands, and engagement with stakeholders and with the United Kingdom. And we have negotiated a final list of proposed amendments, and a draft order has been made and circulated. And so tonight we're here to talk to you about what is contained in that draft and to inform you of the results of the efforts made on your behalf to reform and modernize our Constitution. And so what we will want to do is we, in accordance with our Constitution, begin with prayer. And so the former Pastor Cox come and understand as we go.
What a privilege it is to be able to partake in this session. And I just love God's word as it gives us instruction when we are in need of it. And so I think of James 1:5, which tells us, if any of us lack wisdom, let him ask God, who gives generously to all without reproach, and it will be given to him. So I think wisdom is so necessary. Let us pray. Father, we thank you so much for your word that brings light to our feet. It makes matters clear when there is confusion. My prayer, Father, is that you give us wisdom, and as you ask us to ask, and if we ask, you'll give it to us. As we kind of go through this constitutional reform conversation, Father, I pray that you provide clarity to the people that are in this room as they ask those questions, but also clarity in response to our panelists. We give you so much praise, Father. You're so good. And it's just great that we are still able to call your name out aloud without having to be concerned or worried about being killed for just declaring that you're God and you're God alone. And so we're so grateful. And so, Father, I thank you. I just give you all the blessings and all the glory as we bring your name before this particular event tonight. And so we thank you. In Jesus' name we pray. Amen.
Amen. Please be seated. So yes, ladies and gentlemen, we are here this evening to have a conversation about the results of the negotiations on your behalf for modernization of our Constitution. You will have before you two documents. The first is this document here, which is the draft order to amend the Constitution. If you don't have a copy and you need one, please indicate, because we do have some extra copies in the room, which we can share with you. Yes. So there's some hands here.
No, wait, I have a question. Where can one find these documents online on government's website or elsewhere?
So I'll just come right to that. But you should have this document with you, and if you don't have a copy of it with you tonight, please indicate so that it can be brought to you. The second document which you should have in front of you is this document here, a very colorful one with our beautiful by nature ocean in front of you. This is a plain language explanatory guide to the first document. So the first document is a draft legal document. This is an order that would amend the Constitution. And the amendment will be in this form here. It's written in legal language. And this document is a plain language explanation of the proposals which are set out in the first document. These documents are released by a press release by the government, and so should be on the TCIG website, the government website. And so we can double check that to make sure that we have that available to you, but it was released in the press release.
They're not there.
Right. So, well, I received the press release, so I'm
On
sure
the
I can
government's website, these documents are not there.
The press release tab should have the press release by which these documents were released. But we will double check that to ensure that persons have it. So thank you for drawing that to our attention. So if you have these documents, they will help to guide the discussion for this evening. And we have with us the Honorable Premier, who is, has worked very hard to ensure that these proposals, which were first debated in the House of Assembly and then went around the islands in town hall meetings, we had a survey, we had stakeholder engagement, and there was discussion on talk shows and so on, and there was negotiation in October of last year, face-to-face, between the UK government and a delegation of the TCI, led by the Honorable Premier on behalf of the PNP, with a delegation from the PNP, and the Honorable Leader of the Opposition, who is here with us, who has also worked very hard to ensure that there was bipartisan cooperation and partnership in respect of the proposals that have been agreed in the House of Assembly. And the Honorable Leader of the Opposition led the PDM part of the TCI delegation. We met in Waterloo, in Grand Turk, and I, with a constitutional expert, a senior KC from the UK who has worked on negotiating constitutional amendments for other overseas territories, the modern constitutions. His name is Sir Jeffrey Jow, KC. We were all there together working with the UK government to go through the various proposals. And so these documents represent what we have been able to agree with the UK, and it is an agreed set of changes. The draft order may change, but it only will change to clarify the language, to make it accurate in terms of the cross-references and so on. But we've done quite a lot of work to ensure that it is accurate. But there is ongoing work at the moment to ensure that it is in good order. And the intention is, as it's going through the processes in the United Kingdom with the House of Commons and ultimately to the Privy Council. This is going through the local process here in the TCI, which is to come back to you to report on what we have been able to achieve on your behalf, but also to be debated in the House of Assembly. So this process is, as I said, the last step in the process. So it's not that we are here to relitigate these issues or to introduce new issues, but there will be opportunity to introduce new issues, because you'll see, as a part of the proposals, that we have agreed a process for the establishment of a Constitutional Commission, whose task will be to continue to review provisions of the Constitution and to conduct the necessary research and put forward the arguments to the House of Assembly for the purposes of further negotiations with the UK. So those matters that have not been able to be agreed, of course, will be amongst the issues that will continue to be debated with the United Kingdom through that process. And so there will always be an opportunity to continue in that regard. Of the 34 proposals, 34 proposed changes, of those proposals, there were about 7 or 8 of them, which we weren't able to come to agreement on. but this draft represents all the others. So that's a sort of statistic of about 80%, of the proposals. And these proposals represent very important changes to our constitutional framework to reflect the more modern relationship that we have with the United Kingdom. And it also puts the TCI, it would put the TCI Constitution in line with the more modern constitutions amongst the overseas territories. So this process, as I said, began quite some time ago, and it is the culmination of the work of the two main political parties, working on a bipartisan basis and over more than one administration. This period, which lasts from the 7th of October to the 17th of October, would see the end of that process and culminate in a debate on the acceptance or not of this order in the House of Assembly. That debate will be informed by the meetings that we are having, going around the islands. We've been to South Key and to North Caicos last night. Tonight here with you in Provo, and tomorrow in Grand Turk, and we will end with South Caicos on the 15th. So having said all of that, I think I've covered all of the preliminary points, and I would introduce now the Honorable Premier and the Honorable Leader of the Opposition, who will bring introductory remarks, starting with the Honorable Leader of the Opposition.
Yes, thank you very much, Madam AG. Pleasant good evening to the Honorable Premier, and pleasant good evening to everyone in attendance to this evening. As the AG had said, that this is a combination of a lot of work that has been done throughout the years. This is based on three main sources. The first source was the 2006 Constitution in collaboration with the changes in that we have seen in the British overseas territories in terms of the Constitution, in particular what changes had already been brought into Cayman Islands. The second one is the report from the Constitutional Review Committee that went around the islands, did all the surveys, and compiled that report. That was completed in 2019, 2020. And the third source was the meetings that we had in March of 23, where you had the Premier and his team, including King's Council, my team from the opposition, including the King's Council. You had Mr. Adam Pye from the FCDO office, and you had the Governor, the Attorney General, and the Deputy Governor in those meetings, those deliberations. So this is from those three sources, what we gathered from the people, what we saw in the constitutions, what has already been given. Because the advisors thought that, well, if they had already given this to the Cayman Islands, why can't they give this to the Turks Caicos Islands? So we used that source also, the changes that had recently been made in the Cayman Islands. And many things we had agreed on, we came to consensus on. There were one or two things that we had disagreements on. It being widely publicized. One of the main things were when they talk about the 4 additional seats. My position was that we had enough time since from March of last year to do it with the Boundaries Commission and decide where those seats will be placed instead of placing them at large. So we had, both of us agreed on that all elected members, all members in the House of Assembly should be elected. But a disagreement came on the timing. I wanted that to be done, that review and that consultation with the people to be done before this upcoming election, but others thought that we didn't have enough time. But most things we agreed on and came to consensus. As we go through the documents, I will highlight the things that I may have differed but came to a consensus on as we go through this. So thank you very much, and very happy to be here tonight.
Good evening. Thank you very much, Honorable Attorney General, for the explanation as to why we're here and how we've gotten to this point. I wouldn't rake over old coals, except to say that the Constitution is a living, breathing document, and that it is not the Constitution of the PNP, it is not the Constitution of the PDM, it is the Constitution of the people of the Turks and Caicos Islands. And we have had extensive deliberation and collaboration over a long period of time as it relates to these particular amendments. We inherited not inherited, but a new constitution was introduced in 2011, which I think was informed at that time by the people of the Turks and Caicos. There might have been elements of that constitution which did not meet the approval of everyone within the Turks and Caicos. But I remember that there was a consultation period. I think from a legislative point of view, I don't think any legislator was always 100% happy with the Constitution, 2011 Constitution. Some of that was based on our own assessment, and some of it was based on this assessment and representation made by our public, the public whom we represent. But where we are today is a long period of negotiation. So as the Attorney General has stated, we're not here to litigate what has already taken place. We're here mostly to, as part of the process, to inform the public as to where we are. And as she also indicated, as we will come across again the discussion tonight, there is a new provision in these amendments which provide for a standing Constitutional Commission, so that the Constitution will be under constant review as it evolves based on our own desire. Let me say from the outset that there are two very important issues you will find. One is the Constitutional Commission, which is a part of the amendments, and the other one is a provision that speaks to referenda on any major issues. So that will include the issue of independence, yes or no vote, if that is a desire of the people of these islands. And I know, to sort of preempt one of the things that people may be preoccupied about is whether this goes far enough. What I would like to say that this has been a long period of negotiation, and both political parties have agreed that this is what we will be taking forward and introducing and agreeing to on the 17th of this month. This will be debated in the House. But there's broader agreement that this is where we are today. This is what we are both political parties, that is, have represented to the UK and have agreed through that process of negotiations with the United Kingdom. Again, the delegation from the UK was led by someone from the FCDO. The delegation from the TCI were led by myself, the leader of the opposition, with support, KCs from both sides, and other necessarily give the impression that this is where it will rest for the foreseeable future. So with that in mind, again, I want to thank the AG and the leader of the opposition for their part in getting us to this place. And I want to make it very clear finally that these negotiations, even though the deputy governor and the governor was present in the room, the negotiations were led by your elected members. We made a decision in 22, I think it was March 22, to take on a consultant because we had made 2 previous attempts to have the constitutional amendment. But in 2015, 16, and again in 2019. But I think the feedback from the UK that there need to be more justification for what we were asking for. In both cases, the ask for the UK was more on a point basis, sort of a list basis, rather than a detailed explanation and justification basis. And that is where the expert advice and assistance from a constitutional lawyer professional who had worked with the Gibraltar, who's in other overseas territories, and with the Cayman Islands, was useful to bring him on board to assist us. There are things in this Constitution that is not in any other Constitution, which I believe will augur to the best social and economic interests of the Turks and Caicos. And then there are other elements in here which reads almost verbatim from other constitutions, including parts of the Cayman Islands Constitution. And so, with that said, I'll turn over to the AG to mediate the meeting.
Thank you very much, Honorable Premier, Honorable Leader of the Opposition. The format for the meeting this evening is that I will first give a summary of what is in the order, and then we will take each proposal based on the articles of the draft order. And at the end of each, then we will receive your comments or questions in respect of them and work our way through to Article 22 in that regard. And so, first of all, you should know that the draft order proposes several amendments, and in particular, it proposes changes to the name of the House Assembly to Parliament, and of the ordinances that are made there to laws. And with effect from the next dissolution of the Parliament, it proposes changes to the maximum parliamentary term from 4 years to 5 years. Yes?
Excuse me, can I go up to the mic? Or?
I'll give you time for questions. We're not
No, this
questions.
is not a question. I am actually confused as to why I am here. The rest of us are here because, as the notice said, it's a consultation. Yeah. Right? And consultation means you taking on board our opinions. But yet you said there are 34 proposals and 7 or 8 couldn't come to an agreement. So are we talking about the 7 or 8 that hasn't come to an agreement? Is the other 34 proposals, the other 34 proposals less than 7 or 8 that have agreed in here? I mean, can you clarify why are we here? If this is a discussion,
let me repeat myself. Because I thought I did, but I probably didn't.
That's fine, but
okay.
if it's a consultation, we need to be putting in our input, our opinions. Just already done.
So can I explain? When you are finished, then I will explain. So as I indicated earlier, this is the end of a process. This is not the beginning of a process. At the beginning of the process, there were a set of proposals. Which proposals were put to the country through a set of town hall meetings like this, in relation to which the views of the Turks and Caicos Islands community were sought as to whether there was agreement in respect of moving those proposals through to the UK to negotiate changes to our Constitution. At the end of that process, there was a debate. In fact, at the beginning of the process, there was a debate in the House as to which proposals to put to the country. As the Honorable Leader of the Opposition said, a Constitution Commission was established. That commission went all around the islands and spoke to every community, including to Providenciales in this very room, right? And we heard from the community as to whether there was agreement with putting forward those proposals and in relation to which, what formulation, because in some cases, there were options. At the end of that process, there was a debate in the House of Assembly. The representatives that were elected and appointed debated the proposals and came to a final list of proposals based on the consultation, and that list of proposals was then provided to the UK. In respect of which, I'll come to the end, in respect of which, there was engaged the views of the PDM and their delegation and the PNP and their delegation. And we also engaged the services of a constitutional attorney, a King's Counsel, who had already done this kind of work for other overseas territories, Cayman Islands, Gibraltar, and others, and in fact had partially drafted the South African Constitution. That was, what resulted from that was a set of exchanges, correspondence from the Premier and the Leader of the Opposition, assisted by myself and the constitutional attorney with the UK on behalf of the people of the Turks and Caicos Islands. That culminated in a face-to-face meeting between the United Kingdom delegation at Waterloo Grand Turk in October of last year. That was attended by myself and the constitutional expert and two delegations which comprised the TCI delegation. One part of it was led by the Premier, KC for the PNP party, and other persons who were selected by the PNP. And the other part of it was led by the Honorable Leader of the Opposition, a KC selected by the PDM, and other persons, including, as the Honorable Premier said, the former Premier, Honorable Charlie Cartwright Robinson. And we had a negotiation back and forth on those very same proposals. That then resulted in another set of exchanges, correspondence, and so on, in respect of these proposals. And so now this order reflects those from that list of 34. It reflects those things that have been agreed. And what I said is, that in respect of the 34 proposals, about 7 of them were not agreed. We could not come to agreement in this round of negotiations in respect of them. And so we moved forward with the remaining, which was certainly the majority of the proposals. And so what is here as a part of the process is because we started with the community, asking the community, do you want these proposals to be negotiated with the UK? And so we come back to you to inform you of what has been achieved. What I also said was that when the UK consultant, the King's Counsel, Sir Geoffrey Jow, came to the TCI, he met with a number of stakeholder groups. He appeared on radio talk shows and television talk shows and so on, and engaged in respect of people. He met with all the elected members and appointed members in the Commonwealth Parliamentary Association for the Turks and Caicos Islands. And so this is not that we are coming for people to rubber stamp. On the contrary, this is the end of a process that began with a set of proposals that the community of the Turks and Caicos Islands said we want to negotiate with the United Kingdom. Okay? Yes.
I have one question. You know, settings like this, or other settings around the country.
Can you stand so we can hear you, please?
Let me stand. Yeah. How do you determine what is the settled will of the people on any issue? Do you ask for a show of hand and you look around to see whether if there's 100 people there, 75% say yes, I agree to this? How do you go back and report what the will of the people is? You know? And then you're going to say this here is from the people? How do you gauge what the people, will is?
So Honorable Southwark, once again, I've outlined the process that was used. At the beginning of the process, it was indicated that this was what we were going to do. And this is what we have done. And we have come back to say, these are the proposals which, based on the town hall meetings, I think we also had a survey. There were 2 debates in the House of Assembly. There was a Constitution review report, which was also circulated, of the results of the town hall meetings and other engagements. Persons could write in. We had letters. Those letters were attached to the report as well. And so, this is the process that we have used, and come now to this part of the process. But I've also said, and the Premier has said, the Leader of the Opposition has said, this is not the end of looking at proposed amendments to the Constitution. This is a significant change, but this is not the end. And this significant change that is reflected in this draft is the first time since the 2011 Constitution that there has been any significant change to the Constitution. The only other change was the increase of a minister. So, I think it's far from any kind of rubber stamping exercise. Okay. Honorable O'Neill.
Good night. My name is Edith Skippings, and I am at every town hall meeting that has ever been held, unless at that time I happen to be out of the country. The consultation that was here, that I think that you're speaking about, I'm quite sure that you remember that I was here. And I was very vocal. Sometimes when they have these town hall meetings, there's just a handful of us. No, this is not a handful, trust me. There's just a handful of us, sometimes 20 plus persons only. Tonight, it's the will of the people because the other persons did not bother to come out. So it is the will of the people, because to have a say, you have to come out to have a say. I will pass you back the mic, just a minute. That is the will of the people, in my opinion, because it was advertised, and those persons that wanted to contribute, they came out. I'm surprised that I'm not seeing my good friend, Mr. Devin Williams, here tonight, because he's usually also at all of the meetings that is held. And I have read so far these amendments that is being put forward here, and I must say truthfully, the only thing that I would say that we were against that night that was held here in Providenciales was the 5 years, to increase the 4 years to the 5 years, honestly. So I would pass the mic on to someone else to make a contribution, because I will have a say a little later on. Thank you.
So, ladies and gentlemen, I want us to get started in respect of this process tonight. And, you know, Ms. Gibbons is correct, and I think she was sitting almost in the same place. And I was here, and I recognize the faces of others, including the person right next to Mrs. Gibbons, who was here and had plenty to say, and other people, including persons who spoke a moment ago, you know, and who were here and had their say as well. And I went to every single one of the public consultations in all of the islands. And also that night, the meeting was being broadcast on Facebook. It was being run, that was because they said at one point there were 1,300 people who were watching. And so, you know, I think I'm from Renter, and I can speak about the Renter people, and sometimes people come to meetings to row, and they feel like unless they get a good row out, they have not been to a town hall meeting. You know, but I think what we need to do tonight is at least let's listen and discuss and talk about these proposals so that everyone can know what is here, and there is no one who can say later on that they were not informed about what was being done. But everyone will have an opportunity to speak if you want to in respect of each one of these proposals. So I'm eager to be able to get through the process so that everyone can hear what is here. I will yield to Honorable Garland, and then with your indulgence, ladies and gentlemen, community, let us get started. Honorable Garland.
Thank you. Good evening. Thank you, Madam AG. And I'm going to try to bring some perspective to this. As already been explained, there was a process, and the process was consultations in relation to certain recommendations for amendments to the Constitution. Out of those consultations, there was a committee formed from both sides, from the two main political parties, made up of PDM and the PNP. As AG had explained, we would have met with a delegation from the UK. And when we met with that delegation from the UK, what was discussed, what was proposed, and what was recommended was from the consultations with the public throughout the islands. Coming out of those recommendations, there was a certain number of them that was accepted by the UK. And as EG was explained, there's about 7 or 8 that has been deferred and are still under consideration. Now, my understanding, and for clarity, the purpose of this meeting tonight, even though it said consultation, but it's not actually a consultation. What it is to introduce to the public the final draft of the recommendations that has been agreed jointly with the two political parties in the UK from the consultations with the public of the Turks Caicos Islands. So all of this is to share with you the final recommendations that has been agreed and which will become the amendments to the Constitution. There will be no changes made. It's not intended to be changes made. So that is the purpose of the meeting, to introduce to the general public the final acceptance of the recommendations from the consultations of the public of the Turks Caicos Islands throughout all the islands, and which was finalized at the meeting in October with, as the agent said, the PDM party, the PNP party, and the UK delegation. That is basically what we're here tonight for. It's just an introduction to say this is the final document that is now going to become the amended Constitution for the Turks Caicos Islands. Thank you.
Sorry,
Honorable Delancey, only because I have a soft spot for you. I will allow you to.
I appreciate you very much, Honorable. Once you go down the list, I have a few notations on my list that I want an explanation on. But I believe the lady in front of me was quite right when she said that this is a consultation. I would say to the leader of the opposition and the premier, I don't want you to work unacceptable. However, I believe coming and telling people that we had a single consultation with program here in this room, I don't know where it was, right? To really decide, make a decisive position on the Constitution. I honestly think that there should be more effort be made to garner the support and to the understanding of the general public. Because here we are tonight with a Constitution that is not a proposed Constitution any further. It is something that we are here finding out what is in the next Constitution, right? And so we are at a point where persons in this room still don't understand what's in this document, right? And we can, excuse me, please don't cut me off. And we can blame them for not coming to the last consultation. There are some reasons why some of them wasn't there. You could say, well, people don't show up. But I think that, especially the political parties, right, should make more effort, educate the populace, educate the people of the country as to what your goals are when you're wanting to change the Constitution that governs them. And I think that's the meaning of the matter. I think that's the blowback that you're finding now, or you will be finding from persons in the gallery here, right? This document, the expository document that I have here, I got this evening. And I had to go through it really quickly, and I highlight some points that whereby I would want to get some more feedback as to how it's going to work, why is it in there, and all that. But even the feedback you give me, the impression I got is that it's not going to change anything, because this document is what is agreed, and as the honorable member behind this saying, it's already gone through the process. So I would impress on you two gentlemen, the leaders of the two major political parties in this country, to in the future, to ensure that you have a broader range of consultation with the local population of this country before we enact laws or agree to laws of changing the Constitution that's actually going to affect. I'm not saying this is a bad document. I'm just saying people need to know a bit more prior to coming to the finale of this document being put in the Constitution.
Let me say neither me nor the leader of the opposition was a part of that committee that was appointed by the House of Assembly. Both political parties appointed a committee to go around the islands. Right? I wasn't sitting at this table. It was independently done. The information was gathered by the public. Right? It was then fed, as Honorable Dallin already explained. I believe there has to be some obligation on the part of the public to show up. And this is, instead of being, so that you're not surprised, it was broadcast on Facebook. People who wanted to be here was here. I was here sitting in the audience, right? Not in this position. I was sitting in the audience, asking questions or listening to what other people had to say. The fact that, and this was broadcast, the notices were sent out. Right? So this is the end of the process, and we're here to educate you, to answer your questions, to explain to you any concerns you may have or any questions you may have in terms to try to provide answers to you as to the rationale behind what was done on your behalf. You have elected us to represent you, two political parties. Right? A lot of work went 2 days at Waterloo with professional advisors on both sides. We started out with a list of 19 ARCs in 2015, 19, and we ended up with 34 by the end of the consultation in October. And as the AG has already said, 6, 7 of those were either removed and dealt with through other ordinances, the law, because some of them were not necessarily fit within the Constitution. And then there may be others which will be for consideration going forward. Right? So I don't want to give the impression that this is some kind of sort of a sloppy job where we didn't put effort and time in. And 2 days at Waterloo was the last, and since then there's been communication backwards and forward between the UK and the government and the leader of the opposition. We went through this methodically. Our desire and our aspiration is no different than yours. Every person in this room and every person sitting behind him eventually want to be in a situation where we can have fully self-determine our own destiny. But there's a road to get there, and we shouldn't sacrifice the good for the perfect. What we have here tonight is not perfect, and a constitution will never, even an independent constitution, will never include everything, because there are laws and other means by which certain things will be achieved. So I believe we should be patient. Don't judge the book by the cover. Let us go through each item one by one, and then you can see clarity. And then if you have other matters that you think are not in here, there will be a constitutional commission, a standard one, a one that will be permanent, and will, even immediately after this is done, the Constitutional Commission, once appointed, can decide that they're going to meet once a year, once every 3 months, to hear the views of the public. I think this is a great step in the right direction, right? To sensitize the public, to give the public an opportunity to participate in the democracy of these islands. But we have to start somewhere. We have to start somewhere. This, you know, and so we're starting with what we've got, and we'll try to do what we can. But, you know, I think on balance we've negotiated some good changes. You know.
It's just finally, just to add to what the Premier said, Honorable Delancey, I don't know from the Premier's side, but with us, we had shared this even in the branch meetings, where we had the documents as they were coming up and disseminated, and we went through it in the branch meetings. If you were not at the Southern meetings, then I don't know, but I know we presented this at Southern branch meetings also. So I do believe that the political parties did their part in sensitizing their voters, their supporters, and the government did their part in sensitizing the whole general public also. So I think as we go on, we can add to every clause. As we go to every clause, you'll have a chance to get up and speak and ask questions. So I think we should get started and let those questions start coming through.
Well, wait 1 minute. Right, so this is the document that's been laid before Parliament in the UK. Draft order. Yes. Why wasn't this document itself made available to the public? This is the first time I'm seeing this.
This document was released in the press release that I referenced earlier. 2 documents, as I said. I hope I don't have to keep repeating.
Which press release? When was this press release?
There was a press release that was released, I think, on Friday, and it had the 2 documents there. One document being this document, which is the draft order, and the other document being the explanatory guide, which is this document here, plain language guide. Okay? All right, let us move on, please. Thank you. Would you return the mic to the stand? In terms of the proposals that are summarized here, I'll just start again so that everyone is aware. And so I think I should say that present here in the room are persons who are members or certainly participated enough to be called members and referenced in the report, in this room this evening. And I won't name them, they can identify themselves on their own. But I'm sure that they would also speak up in relation to some of these things as we move forward. So the draft order proposes changes to the name of the House of Assembly to Parliament and ordinance to law. Could I get through it, please, and then we will have a time for questions on each item. All right, Mr. Williams, you can come in and have a seat, and then we will have an opportunity. So each proposal we will have an opportunity. Mr. Williams, I'm going through a summary of what is in the draft. Then we will take each proposal. All right, so it also proposes, after the next dissolution of the Parliament, it will change the parliamentary term from 4 to 5 years. It abolishes the appointed members of the Parliament, other than the Attorney General, and the 4 appointed member seats would become elected member seats. It clarifies that the Turks and Caicos Islands Cabinet has autonomous capacity with respect to domestic affairs. It sets out matters relating to external affairs that the governor must delegate to elected members of the cabinet. It makes provision for the governor to appoint a greater number of ministers other than the 6 normally permitted, and so there would be 9 in total, including the Premier. It establishes several new bodies, a cabinet office and a cabinet secretary, a police and defense service commission, an international center for our alternative dispute resolution, and provides that a constitutional commission may be established. It makes constitutional provision for some entities and items already in existence, including the National Security Council, the TCI Regiment, and the National Crest. It removes the regulation of international financial services from the governor's special responsibilities and establishes an independent body for the regulation of financial services, which can be under the portfolio of a minister. It provides a power for a referendum to be held on matters of national importance, and it identifies independence as a matter of national importance. It makes amendments to the composition of the Electoral District Boundary Commission and its functions. And so that's a summary. Now let's take each in turn. First of all, the Article 5 of the order, the current position is that bills are debated in the House of Assembly, and when they are debated, they become ordinances. When they are passed and assented to by the governor. The proposed change, in keeping with the change of the name of the House of Assembly, the bills of the Parliament, of the new Parliament, would be called laws rather than ordinances. So we can take these two together. The name of the House of Assembly would be changed to Parliament. And so the work of the House of Assembly in terms of bills would result in laws instead of in ordinances. The way that the ordinances are used elsewhere is usually in respect of municipalities and regulation of areas, smaller areas, whereas the expression law is more in keeping with with the work that a parliament does. This is in keeping with modernizations in the constitutions of the Cayman Islands and Gibraltar as examples. So that's the first proposal. Are there any comments? First of all, from the table. Any comments from the floor? Please do come to the mic. Please do come to the mic. Come to the mic.
I think I can speak loud enough for everybody here. I'll come back. I don't want to take up too much time because we have a lot to go through. So, and I just want some clarification. So, basically, in terms of what you're saying is that when we change the House of Assembly, we have to change from ordinance to law. Is that the basic principle you're telling me?
Both of those
So once we
states.
change the House of Assembly, then instead of having ordinance, we'll have laws.
Well, there are two proposals. So they go to hand in glove. But if you change House of Assembly to Parliament, then you don't want to have ordinances coming out of the Parliament.
Right. So basically, the laws would be from the House of Parliament. It's basically what the ordinance would be from the House of Assembly.
That's correct. Yes.
That's what
Man, we trying to listen. Sorry, I don't know what the line is.
Any other comment on that or a question? Mr. Bain?
Yes, in terms of the question that was just asked, relating to laws instead of ordinances, in the case of the outcome being law from Parliament, but the governor still have to assent after Parliament has debated.
Yes. Because this is not an independent constitution. So the governor would still have to assent to the law.
So it's just a difference in terminology, basically.
Yes, and it reflects a more modern approach. And so it should rightly be made. Yeah, even in independent countries, governors assent to the laws that come out of Parliament. Yes. Anyone else? Yes, I pass the mic straight down.
I think we are put at a disadvantage here. We could have read this, had this been made available to the public, read this with the substantive law in front of us, and to refer to these amendments. Right now, it's like, where's the substantive? I see something here, it just changed 4 to 5, referring to a section of the Constitution. Had we had this beforehand, we could have read this and be more prepared for this discussion, not
But
consultation.
Ms. Bell, this proposal has been around since the beginning of the process.
No, I'm talking about the
And in
proposal.
relation, let
I'm
me
talking
answer.
about this draft order.
If you're going to ask a question, then you have to allow me to answer. If you look at the plain language guide next to the order, you will see that it references an article. You'll see that in the plain language guide, it says Article 5 and it says Article 6. So it directs you as to where to go in the order. Thank you, ma'am, but you failed to get the gist of what I'm saying. This is a legal document. This will be a legal document. This is a draft order. Most of us got this today, and we're supposed to have a discussion on this, which is an amendment to the Constitution, without the Constitution in front of us. You don't get it. The Constitution is
This
available.
amends the Constitution. So we should have the Constitution in front of us while we're reading this.
The Constitution is available publicly, freely, online.
I just got my hands on this draft order tonight.
Ms. Bell, you are my learned friend, right?
Of course.
And I know.
And you should know
I know
that you just spring this thing on someone just like that.
No, ma'am.
We should have read this beforehand.
This was sent out in a press release, Ms. Bell. I don't know if you're going to continue to, we've heard that point that you made, and you're saying you feel personally that you want more time, right? The debate in the House is on the 17th. If you review it and you want to provide that feedback to anyone, including myself, I'm happy for that to be received from you, to be included in the debate on the 17th. All right, thank you. Yes.
I did have a question. Oh, Councilman.
Good evening, everyone. Just for clarification, current ordinances, will they be changed going forward? They will be changed to laws going forward.
Yes, that's correct. So where there are references to ordinances, that will be a reference now to laws.
Okay, so this will be retro.
Once it has effect, once it comes into force, it will have that sweeping effect.
Okay, understood. And then I guess that is the second question, which is, when do you expect that these amendments would become effective?
Thank you for raising that question, because I did intend to say at the beginning. So the course that we're on at the moment leads to the Privy Council at the near to the beginning of November. Should be around about the 4th of November. The Privy Council, the processes within the UK, which are being worked through in tandem, should lead to the submission of this. Right, so the date may not be exactly correct, but it is at the beginning of November. Certainly by mid-November, this process should be concluded. Yeah.
Is there someone in the UK where we can send written submissions on this matter?
No, there's no one in the UK that you can send written submissions on this matter. If you have written submissions, your government is here and your opposition is here, and you can provide your submissions to them. But if you want to send submissions to the UK, you can. It's the Foreign Office, and you can write to the Foreign Office.
Who at the Foreign Office?
I have no idea. Any other questions? I think we have to be masters of our own destinies at some point.
Yes.
Any other questions? All right, so then moving on to the next proposal. Yes, sorry, yes. Come to the microphone.
My question is in relation to Mr. Laporte's question regarding
those ordinances guide a lot of our day-to-day operations, businesses, and the way we live here in Turks Caicos. Have we given consideration to, first and foremost, I think it's very important to understand the differences between an ordinance and law, and what implications something happening into law, being a law versus being ordinance. Some perhaps can have greater weight than the other, right? And perhaps you can help me with that understanding also. Because when it's passed into law, I think really, it is what it is. And so it's very important for us who wants to give some feedback that these what may seem like minute, so to speak, changes may also be affecting some wider things that we are guided by. For example, the Crown Land Ordinance is now going to become law, and there are no leeway whatsoever that perhaps we may have some leeway, the cabinet may have some leeway with ordinances, but we know we don't have no leeway with law, because we know, as we say when we argue certain cases, that's the law, and finally, that's final. Right?
That's a very good question.
So to make, I think your question,
so, you want to repeat your question? You're up to about 3 at the moment. So, yes.
okay. So I just want to, I think it's really important that folks that want to really give some good feedback really understand in depth that I support this thing, or certain elements of it, knowing the implications of supporting it once it's law. And so I'm just really zooming in on Ms. LaPorte's question, because we live by a lot of ordinances and such.
Yeah, that's a very good question, and it follows on from Mrs. LaPorte's very good questions as well. And it's important, I mean, the lawyers in the room would be able to assist you, but I'll just assure you that the legal effect of an ordinance or a law, a document called an ordinance or a document called the law, is the same. And so there is no restriction or prohibition to the cabinet or to proposing to the parliament amendments to the law when it is made. And so you should be assured that that's not going to create any kind of roadblock or restriction. As it relates to ordinances that are here already, just in the same way as the references in our law to the Queen. And so, for example, in our Constitution, it refers to the Queen, and in several pieces of legislation. But there is an act of the UK Parliament which says that there is the continuity of the sovereign, and so where you see the Queen, once the Queen has passed and there's a king, Her Majesty becomes His Majesty. So even though you see that word, those words written in the text, that that law informs that when you read it, you understand that means His Majesty. So in much the same way, when the Constitution, because that change is reflected here in this draft, and what it says is that for where you see the expression ordinance or ordinances, read law. So Crown Land Ordinance becomes Crown Land Law. Okay? Thank you, but those are very good questions. Could you come to the mic, please? Could you come to the mic, Mr. Forbes? I believe Mrs. Forbes is here. I believe Mrs. Forbes is ahead of you. So it gives you time to come down. Mrs. Forbes.
Hi, good afternoon, everyone. Just want to confirm that the process for bills becoming in effect is the same as law. There's nothing procedurally that is changing.
Very good question again. And the answer is yes. So procedurally, it would remain the same. So whereas before this order is made, the House of Assembly would pass bills, which when assented to become ordinances. The Parliament, the new Parliament, would pass laws, which when assented to, bills, which when assented to become laws. Okay. Thank you. Mr. Forbes, I thought that gave you enough time to reach down.
Madam AG, I think it would be helpful if we could just pass the mic around.
I was, and then somebody put the mic in the stand.
Yeah, I think it's a lot
When you
easier.
go faster when you're passing the mic along.
Well, I think you can get it. You have higher authority. Perhaps you can get it. Yes, the higher authority says you can get it. Yes, because persons over there are saying they have to have you speak on the mic because they can't hear.
Yes, good afternoon. I'm not sure whether it's your office or several offices, but it looks sad. I was talking about the notices that were sent out. It looks fair consultation. So I believe that's the reason why you was here, but alcohol early on. Because when it came to it's not consultation, but it talks that now. When you in the introduction, you spoke of the modernization of other overseas territories, right? But in terms of the makeup of their parliament, could you give me at least 2 of the overseas territories that's in line with these modernization territories?
Thank you, Mr. Forbes. So the Cayman Islands and Gibraltar are 2, and those are available online as well.
Yes. What is the name of the Cayman Islands and Gibraltar parliament? Just to say they have 15 active members, right? If this constitution changes, we'll have to move from 15 to 19, and out of that 19 candidates, 9 of those persons will be elected by all Irish candidates. So I'm talking about that kind of
I know that that concept exists in some of the territories. I'm not sure if Cayman is, I know that the Virgin Islands has that concept.
As the concept is the one that's now being proposed.
Yes. No, it's not proposed here, you know. That concept was proposed, was included in the 2011 Constitution.
Yes.
Right. So that is in the Virgin Islands Constitution, but it may be in others. Well, I think the discussion between the 15 to 19 is coming up in one of the proposals. I will talk more detail about that as well. Okay. All right, if there aren't any more questions on those, I want us to move on. And next is Article 7, and this deals with removal of appointed members, composition of the legislature, and qualifications of elected members. So this is the one that I was referencing. So currently the House of Assembly is comprised of 21 members, 15 elected, 4 appointed, the Attorney General, and the Speaker. The proposal is in keeping with the Modernization Initiative after the dissolution of the House of Assembly. The 4 appointed members would become elected members with the following consequential amendments. And this, Ms. Bell, the references to 7.1, 7.2, etc., are the references in the order. So in respect of 7.2, the formula in the Constitution would be amended to allow the appointment of an additional minister for a total of 9. It says in addition to, but it should say including the Premier. At the moment, there can be 8. It would also allow for an amendment to increase the number of elected members from 15 to 19 after this order is made. But there's another amendment that we're coming to that touches on this. And it's also amended to clarify that whereas previously the speaker could be, you know, there are two ways to have a speaker. You can bring a speaker from the outside, and the members in the House can vote on that person becoming the speaker, or from among the members, the elected and appointed members, you can have a speaker. But because the appointed members go away, it means that from the elected members, the speaker could come. And so that's a consequential amendment that is made because the appointed members go away. It also amends to clarify that for the purposes of elections to the Parliament, the islands shall be a single electoral district and return not 5, but 9 elected members of the House of Assembly in the single electoral district, or what's called commonly the all-island district. And it was also amended so that a person who, and under the Constitution as it is now, the qualification to be elected to the House of Assembly, you have to be 21 years old, you have to be a Turks and Caicos Islander, and you have to be resident in the islands for 12 months of the 2 years immediately before your nomination. But this proposal would extend that 2 years to 3 years. So it's still 12 months, but it gives you a 3-year period to qualify for that. So those requirements would remain the same, and just picking up on some questions that we got on other islands, the requirement to be a Turks and Caicos Islander is not changed in any way. It is retained in the Constitution. So it also would clarify that a person who automatically acquires or who has acquired nationality other than British nationality, including by way of birth and descent, are not disqualified from being an elected member of the Parliament. Persons know already that at the moment, a person who acquires a citizenship, say, to the Bahamas by virtue of their birth or through descent is required to renounce that citizenship, whereas that person did not take any step to acquire that citizenship. That citizenship came automatically by the circumstances of their birth. And so what this provision would do is it would change that so that where a person has the automatic citizenship, that is not a disqualification. And it finally also allows where persons prior to the order coming into force who had that automatic citizenship but who renounced it, those persons have the opportunity to reacquire that citizenship without being disqualified, without any kind of penalty. So all of those proposals, yes, all of those proposals are in Article 7. So any comment on those, any one of those proposals?
Yes, before you go, Madam AG, comment from the table here. Just to let you know now, so with the 15 moving to 19 elected, the numbers in the House of Assembly will remain the same. It's just that everybody will be elected now. There will be no more appointed members in the House of Assembly. So for this election, when you get your ballot paper, you will have your constituency candidate, and you will have at least 18 other members to choose from, to choose 9. 9 from the, yes, 2 ballot papers. So the second one will have at least 18 members, because the PDM will field 9, the PNP will field 9, and if there are any independents, you'll have 18 plus. So when you get your first ballot paper, it's for your constituency candidate. The second one will have at least 18 individuals to choose 9 from. And the next point is, if, for instance, Mr. Cox, if your child was born in Miami, but lived all his life here, don't know anything, only go there to visit, we cannot say, you cannot say that he cannot stand for elections without renouncing his U.S. citizenship. Because only because of his birth, and you and your wife have to take him over there to be born. But he didn't do anything to acquire that. He didn't went, look, I want to be American. He acquired that because of his birth. But when he's of age, and if he want to run in an election here, there's nothing saying that he have to renounce that citizenship before he can run.
So you got some folks that renounce and some have not.
Okay, so we need to have the mic go out so everyone can hear. Honorable Lancy, and then to this gentleman.
Thank you. I sort of appreciate that last clause with the automatic citizenship. I just hope they don't come at one point to bite us back in the butt because of some other issues that we have to at some point, but that's for another discussion. But I think it's all appropriate that persons of Turks Caicos heritage who was born in another country, no reason of their own, shouldn't have to give up that citizenship to be able to run the action. I think that's the approach that everyone is looking at. Let me go to the change from 7.2. The formula in section 31.7 is amended to allow the appointment of an additional minister to a total of 9 in addition to the premier. The former member of parliament, you know my thinking about that? My problem with that is, backbenchers in parliament, they ain't gonna have no say. Because you got 9, you got 19, if the opposition get 1, like we have now, you still, the backbenchers still ain't gonna say when it comes to what the cabinet wants to do at all. But what you mean they're not supposed to? What you mean the backbenchers not supposed to?
Honorable Lancy.
If you put order to injection, the parliament is checks and balance. Not necessarily the cabinet. The parliament makes the checks and balances. And so that's why I see the numbers are being skewed with that additional. I'm not saying it's, it couldn't work. That's my concern.
Honorable Lancy, that is all. Let me just address that.
I'll just put you all so you can answer.
No, let me address that one, because I will forget. So that concern is a valid concern, and in relation to that, in terms of how the provision is worded, in order to get the 9th minister, it has to be, the Premier has to be able to demonstrate that the checks and balances, the oversight function of the House is not compromised. And so that is within contemplation in terms of ensuring that the oversight function that the House backbenchers members provide, that is retained.
Yes, and
so that
just to your point right there, I do see what you mean, because the Cayman have that problem where a lot of the committees of the House cannot function because everybody are either ministers or junior ministers. So who will do the Appropriations Committee? Who will sit on the PAC Committee? So I do understand what you're saying there. And I think with that, with the Premier have that ability not to compromise that, but I do get what you're going there. That is happening in the Cayman now.
So, Honorable AG, just because you brought up a point, just answer me one question with this scene idea. Who is going to ratify that potential appointment of an additional minister? Is it going to be left to the Premier to say, I want an additional minister? Or are we still having now go back to the UK government and say, we want another minister, will you allow us to have another minister?
No, so the change will be made so that it can be done within the TCI, with the governor, that ministers are appointed on the advice of the Premier by the governor. And so the governor has her good governance, his good governance function. And so it's the governor who has to actually say, well, yes, the oversight function in the House is not compromised by appointing this additional minister.
So the Premier will still have to go to the governor to ratify this kind of minister. Is that what you're saying?
Yes, to appoint the minister, to appoint the
to appoint to ratify the appointment of the consultation. Okay. Sorry, I don't want to take up all your time, but I'd rather go to what I see here. I don't want to. So I'll do my thing.
I should be finishing one thing, you're going from one to the next.
Well, no,
You're still in Article 7, right? You're not coming. Honorable Lancy? You got a lot of things to do tonight. I just want to make sure. No, it isn't what I'm saying. To answer the concern raised by Mr. Skipping, you are still asking questions in respect of Article 7.
Yes.
Right.
Yes.
Continue.
Yes. Of course. Now I go to 7.5, Section 4.5, 45, 2 is Amendment 35, that for the purpose of election to the Parliament, the island shall be a single electoral district, and shall return not 5 but 9 members to the House of Assembly. Now, I know maybe some people don't understand what I mean, but I mean that you're going to have 9 all-island members instead of 5. And I would really like to know the rationale behind that. In the regards, and this is not a political observation I'm making here, right? For any political party or anybody in particular, or any stands, but I know that the people in the communities in Turks Caicos are looking at their community representation for that actual thing that the communities need, right? And I honestly, and something I'd like to say, I honestly don't think all island candidates are those persons to actually represent the communities, community by community. Yes, they represent the whole country to a broader extent. And I am trying to find out the purpose for making those extra 4, which was the appointed members position, to be now all island candidates, instead of getting the bond commission to deal with more districts, at least 2 districts and 2, if you want 2 districts and 2 all island candidates. So if Honorable AG, I beg your pardon, but I wish that one or 2 gentlemen would answer this question.
Yes, I'm ready to answer it. So this gentleman will answer it. Yes, thank you very much, Honorable Delancey. Going forward, what we wanted was for those 4 new elected seats to go to the Boundaries Commission and they decide how they will distribute them. Whether we're going to give Solkey their own MP, whether we're going to give Middle Caicos their own MP, split some of the bigger seats into 2 and move forward with those 4. However, it was said that the Boundaries Commission informing that and the terms of reference to give them that power would take some time. Now that is where the disagreement we saw in the news where we did differ, because I wanted it to happen before the elections took place, but it couldn't happen before the election, so we had compromise. So, but Article 13 addresses that. But when this Boundaries Commission is formed, they can come back and say, instead of having 9 all-island elected members, we only have 2. We'll take 7, make 7 new constituencies. So with this in place now, with the Boundaries Commission doing their work, or if it is the people's wish, we could do away with all-island candidates altogether and just have constituency candidates. So that is the will, if that's the will of the people. But the Boundaries Commission must do its work. However, we were told, persons like myself, who wanted Solkey to get back their seat and Middle Caicos, that it couldn't be done in time for this election here.
Yes, I have a question as it relates to this whole business of renouncing. From the consultations that you did, did the majority of persons indicate that they would like to see that go away, or was it some committee that made that decision?
Yes, thank you very much. I can tell you from someone who went through all the recommendations, it's at the majority of every island, because past person cited that many of them are having their kids overseas now, and they don't want their Turks and Caicos Island child to be penalized because they had them overseas. So throughout the islands, if you look at the thick report, it said they had consensus at each of the islands on that matter.
Good evening. I would like to recognize you extended the period where a person can be resident from, moved it from 1 out of 2 years to 1 out of 3 years. My question is, why have it at all? For example, a student goes off to college, they're there for 4 years, return home, or you bring them home in between that to vote, but an individual can come home and they can't run in an election. So why is it that you still put a penalty on persons who are not living in the jurisdiction, whether they're Turks and Caicos Islands or not?
It doesn't apply to students.
That's right.
It doesn't apply to students.
Only students that doesn't apply, so you're still residents.
They're still residents.
Okay. That's it.
In front and the skippings and someone else up there? Okay. So the skippings, the Salvo, Honorable Saunders.
Good evening. So, for clarity, if the Lama status was bestowed on you, you can run? Oh, okay, I just wanted to make sure with that one. So when people call me tomorrow and I can talk on the story, I will have it straight. Thank you.
Yes, but there's no change in that regarding this draft. That is the position as it stands under the current Constitution.
Yeah, thank you.
One and all. You know, it's a couple of years ago when we had the constitutional change. I forget the lady's name. Who was here? It's out. Thank you. Back then, like tonight, up against this all island candidates, I recall all their constituencies. Because that there is very dangerous for Turks and Caicos Islands. If you don't know what I'm talking about, if you don't know what I was talking about back then, I hope you know what I'm talking about tonight. Okay? We are getting fewer and fewer Turks and Caicos Islanders, and we call indigenous Turks and Caicos Islanders here. And now also changing whether you can move from 2 years, I think, to 3 years. Boy, that's a gray area. Because you may need a couple of your people to rush back in the states. And time to do. Because we can be on the outside looking in as Turks Islanders. Let me tell you something. I would prefer to see 2 whole islands, the 2 leaders. Because I don't know third party family in my lifetime, but I definitely know we got PBM and PNB. And then if there is a person that's running independent for some reason or another that is open, it becomes law. Your other persons can run for premier or for premier of this country, like the president in the U.S. I vote for that. But that's all island 9 now. 1 coup in this country, they found a racist system. We can be outside, I say, looking in. I ain't hating nobody, but it's a reality. We need to be careful when you sit in government, what you're doing on behalf of people. So I made it enough for me. Because I come out here to make just like Ms. Stevens, and I voice my opinion. You all know that. Now, if there was a meeting that I was at home, I probably was obeyed with, I was obeyed with treatments, or visiting one of my children. But you don't have meetings in my country, and I ain't gonna be there. Not me, and I'm going to speak my speak. I'm going to say my say. Whether and you hot my leader up here at the last week, or you hot my premier, Washington, Mississippi. But I can say what I have to say. We must be careful. And even though small female only has 6 votes, that's an island. Middle Caicos might only have 30 votes. That's an island. Give those people the right to vote, even if it's just one. Carry the ballot box up and let them believe that's right. We must be careful, Honorable Premier, Honorable Leader. We must be careful, you know who you're dealing with? I get 2 boys coming, great-grandboys, sorry, twins. You're messing with my great-grandchildren. You all look at that. And I got another one coming from my granddaughter, one. My 3 great-grandchildren right now. They'll mess up their future in Turks and Caicos. We got people leaving our country. Our beloved, beautiful Turks and Caicos Islands. Because we're afraid. We don't like what we're seeing. Every morning you go, when you go to sleep at night, you wake up in the morning, a young man is dying. While sitting here talking about whether or not you got just going into law or ordinance. I don't want to hear that kind. I want to hear the meat of this. We are not babysitting here. We understand exactly what's going on. Already all those things. No? They already said tonight that this bill is already passed. So they're just telling us what they're going to be doing next couple of weeks or whatever, or next week in the House. Everybody will say, nay, yay. The ayes has it because it's 15, 14 to 1. So they're gone. And not like my leader on board, it's gone. It's law. It's law. Well, I can tell you all this tonight. When Kate Solomon was here, they called me rude because I thought you oppose amendments to the Constitution. You oppose by power. When I oppose Constitution, that I print in my house, and I went outside in front of it, I lighted a fire. It was not my Constitution. So don't say I am lawless. I know who I am. I was in this battlefield of politics from 1975. 1976, even though I had a vote, I couldn't vote because voting there was 21. And I was 19 years old. So you all young people in here who talk about running for government and stuff like that, and who talk about support, you all gotta know what you're standing for. Because if you don't stand like this old woman, 67 years old, you can fall for anything and you don't get nothing. And while I'm on this case, please, I wish I was on TV. Young people, young men, Turks and Caicos need you. I need you. I got granddaughters I need you to live to marry. Stop trying your young lives away. I need to see you right here in your space. And I need to tell you God bless you. I need to tell you I love you. Put the guns down. Put the knives down. Let's have a meeting for this, but that's my voice now. That's the opportunity. All right. Let's use it. Yes, ma'am. Please, while we're talking about new laws in the Turks and Caicos Islands and new constitutional changes, take the rightful place. Stand up. Love your country. Go off, get your education, and come back home. I love you, Turks and Caicos. Good night.
Thank you very much. I was Congress response. He did ask earlier. So I just want to address 2 things. One, that the expansion from 2 years to 3 years It's not restricting. It's actually creating an environment for a person, or a greater number of people to qualify. So that may have been read as if it was somehow limiting, but it's not actually, it's broadening. The second thing is that we have Article 13 to come to, that the Honorable Leader of the Opposition referenced. And so in that regard, we won't talk about it now, but the concern in respect of the 9 versus 5 will be talked about more under that article. Honorable Saunders?
Thank you. I was actually going to pick up on that on two things, because I think the leader of the opposition, I think he misled you a little bit was one of the things about these things. From a good governance point of view, it's very difficult to have a certain amount of critical mass to give places their own constituencies to be able to run. So I know this is that if you have 1 or 2 people in Salt Key, why don't you give them their own seat? The reason why you can't is because it makes it easy for corruption purposes. And so it makes it very easy. How I can explain the reason I can do this is because if you have 5 people in a place, well, you easily can take $10,000 from each one of them. So I'm saying that's how it's defined. I mean, I'm telling you this is how it's defined. And so from a constituency point of view, they want to have a certain amount of critical mass. And what they try to do with the boundary commissions is try to get all of the constituencies to all get those equal. So you don't have one constituency with 2,500 voters and another one with 300 voters. And so they try as much as possible, from a good governance point of view, to try to get the constituencies lined up as much as possible. That's the reason why some places, after they fall below a critical mass, they try to combine them together. So they take Salt and combine it with Rankin South, they take Little Caicos and combine it. Now, from a cultural point of view, certainly from a cultural point of view, everyone says that they're different. Salt is different from Rankin South. South Caicos is different from the other one, but South Caicos is now starting to fall below a critical mass. And so South Caicos is being threatened to be that. In order to keep a good governance principle, to be combined with something else. So what you have to do is you're going to have to repopulate those places so you can get above that critical mass to be able to justify it from a good governance point of view. I'm just telling you really that that's why it's being doing that way. And that's one of the reasons why the leader of the opposition's point that if you give someone where there's 15 voters, then it wouldn't happen. The other thing about it also is that I know he touched on it and says in the future we want to completely go away from the enlarged. If you're going to you can do that. That's not really the case either, because in the Constitution it speaks to the 5 enlarged person, and now it's moving up to 9. I was going a little bit farther than the AG said they're going to speak to the reasons why we got up to 9. I'll just leave it to this, that should be more temporary, go back down to 5. But the 5 is already defined in the Constitution. You can't just go away with it and say, let's move to all constitutions again.
With due respect, honorable member, you can change the Constitution to remove that thing from 5. That's how you say it.
But with the amendments that's coming, you can't do it. With the amendments that's coming, you can't do it. Yeah.
Yeah, so we'll touch on that some more under Article 13. I just want us to have an orderly process. Mr. Bain, were you going to sort of follow that? In which case we can take it under 13? Okay, so we'll take it under 13. Oh.
My question is for clarification purposes. The persons who need to be elected members to the House of Parliament, I would want to know, understand what it says here in terms of if they would have acquired status, citizenship in another country, being one Turks Caicos Islander, would they, and having the ability to have dual citizenship, would they have to renounce their citizenship in order to be an elected member? This is what I'm wanting to understand.
Thank you for that question. So what this provision, at the moment, the current provision, a person who has another citizenship is under an oath of allegiance to that other state. And so what the Constitution would require is that the person renounce that other citizenship before they stand for election on a strict reading of the Constitution. In the proposal, where that other citizenship was acquired, not by an act, like not from an application or something, but just because of the circumstances of their birth or because they were born to persons from, who had acquired the citizenship by descent, they would not be required to renounce because it was automatic and it did not, they didn't have to take any action to acquire it. They didn't have to make a choice.
So just continuing on from the First Lady's question, may we know what brought about the changes to the renunciation, what have you, of their citizenship of the other nationality, number one. Number two, the way I'm reading these two sub-paragraphs tells me that this change is in the best interest of a person who has dual citizenship, or they just find themselves in a pickle of having another citizenship and they need to renounce it in order to be an elected official here. How does that benefit us? If, say for example, if how does that benefit us if there aren't qualifying criteria, so to speak? So I just want to ask the Honorable Leader of Opposition earlier that these changes came about as a result of some of the prior consultations that other islands have said that, I want my children to come back home and I don't want them to be at disadvantage, right? So, do you understand my question?
Yes, let me take the question.
Okay.
So what the reality, I think when we came on the last occasion, I just want to correct one thing.
For me, I find this, not to interrupt you, but I find that for me, perhaps not having further debate on it before, it sounds like a person can be swapping.
In addition to that, what we're also trying to understand is that a person who were born Jamaican national or any other national, just using that as an example, right, can come to Turks and Caicos Islands, acquire status, belonging status, and they do not have to renounce their citizenship with their birth country and still be able to be elected member of the House of Parliament of Assembly here. No, but what I'm saying is still the same thing. If the person is born in another country, let's say for example, if it's a born Jamaican, comes to Turks and Caicos, acquires status, legal status, becomes a belonger, they can be elected in the House of Parliament here in Turks and Caicos. But a Turks and Caicos Islander who was born here, who had Turks and Caicos Island status, who acquired another country status, have to renounce that citizenship in order to be an elected member. Am I right or am I wrong? Can I please just get some clarification on this? Their citizenship and their country. The Bahamian or the Jamaican or the American don't have to renounce their citizenship from their country, even though they came here, acquired our citizenship, and now is being able to be elected into our House of Parliament. And the Turks and Caicos Islanders who born here, who spent all their life here, who acquired status from another country, they have to renounce that. That's a problem.
That isn't happening. No, just a moment. Miss Rochelle. Okay, Rochelle. All right, I see. Rochelle, you've asked a number of questions. You have to give us an opportunity to answer. So in respect of the provision that is proposed, once again, if you as a Turks and Caicos Islander acquires a citizenship automatically by birth or descent, nothing that you chose to do, no action that you took, this provision would not require you to renounce that citizenship, would not require you to renounce the citizenship. As it stands now, you would, but this is curing that issue so that the reason, just to go back to maybe 4 questions ago, the reason is that if we earnestly look at Turks and Caicos Islanders, right, the same thing that my cousin Emma Jean was talking about. You're good, my good cousin, resisting saying good for other reasons. The Turks and Caicos Islanders, and I see Honorable Robinson is here, and I saw Honorable Gardner earlier, but I'm not seeing him at the moment. When we came here on the last occasion to talk about these things, we had a panel of persons here at the table from the PNP and the PDM and me. We went down the line and we asked the audience, who do you think is the Turks and Caicos Islanders? And they said, well, we think all of you look like Turks and Caicos Islanders. But then we sort of talked about the circumstances of our birth. And one was Honorable Sean Astwood, one was Honorable Akira Missick, right? We went down. And the only person on the panel that had 2 parents born in the Turks and Caicos Islands and themselves was born in the Turks and Caicos Islands was Honorable Don Gardner. Right? Remember that? I was born in the Turks and Caicos Islands, but at the point of my birth, my father was Bajan. My mother was from Turks and Caicos. Honorable Akira was born in the U.S., right? Honorable Sean was born in the Bahamas. And Honorable Doug Parnell was born to a British father. So when we went down, that was the circumstances. But that panel, as we discussed then, was not unique. Because actually, when you look at that group of people, you can find that amongst all Turks and Caicos Islanders. You can find perhaps your own children, some of whom may have been born in the Bahamas or in the US, right? Maybe a father may not be Turks and Caicos Islander at the point of their birth. My good cousin, Emma Jean, could probably find that in her grand and great-grandchildren, right? We tend to have children, maybe in the US, maybe in the Bahamas, at one point in Jamaica, and so on. So what was being discussed around the islands in respect of this issue was when you look at the composition of Turks and Caicos Islanders, not question mark at the end of it, but Turks and Caicos Islanders, full stop. We had a lot of dual citizens who acquired that not because they made an application or made a choice, but because of the circumstances of their birth. And so the question was, should those people be barred from running? And the answer from the community was no. And that's what this is about. And that's why it came about. So that's where it benefits Turks and Caicos Islanders. Right? So I think Mr. May.
I think her question was, she wants to understand that if a Jamaican, real Jamaican, right, they came here, they acquired citizenship, right? They married me. They used me to get their papers, to get their papers. and now they come to run. When they come to run, her question was, would they have to denounce their Jamaican citizenship? I think that was the question.
So that has to be governed by the law of Jamaica. But that person would be
pertaining to us,
But as pertains to us,
They're Jamaican, they're acquired Turks Island citizenship.
this would not require them to do that. But as it relates to the Jamaican law, so everybody is treated the same. Right, so yes, that's up to Jamaica. That everybody then, let me say one more time, everybody then would be treated, every Turks Caicos Islander would then be treated the same. They would be treated the same. Nobody would be in that scenario. I understood from the question was whether there was a difference of approach, that if Turks and Caicos Islanders acquired that citizenship, they would be required to renounce, whereas another person would not. That's not the case. This provision would cure that. Well, that is a new proposal, and so we would have to.
Hold on a second for me, please. Hold on a second for me, please. Because we can't police somebody else's country law. Now, hold on a second. Could you just hold on a second, please? Can you hold on a second for me, please? In Jamaica, if you were born in the United States, right, you can run. If the same situation, if you choose to adopt an American citizenship, you can't run in Jamaica. It's the same thing for them. It's the exact same thing. We can't police their laws and tell them who they're allowed to run and not to run an election.
I don't think that's what she's asking. I think you're misunderstanding what she's saying. Her question is, would it be a requirement under Turks and Caicos Island law that if a person that is not of natural status moves to Turks and Caicos Island and is given status through, belongship status through grant, will the government would the laws of Turks and Caicos require that person, not Jamaica law, to denounce their Jamaican status because their original status was from Jamaica, not Turks and Caicos? That's the question. And I think that's a very valid question, because it's right along the lines of what I was going to ask, right? Which is this, and it's going to go right back to the point that Miss Emma Jane was making. We're going down a slippery slope, okay? And we have to be men enough and have guts enough in this country to make sure that in our parliament, no one who has been bestowed without any roots in this country, either by birth or by, and when I say birth, the Constitution says that anyone that is born in this country to at least one parent that is legal at the time of their birth is considered a citizen. That's what I understand as a citizen.
No, it's not. No, I think that's just a moment, and I want us to regain composure. In relation to the statement that was just made, that is not correct. It is not correct. And so I don't want, I think we need to stick with these proposals. Remember, at the beginning of the meeting, what we said is that these proposals have gone through a process. It does not mean that other proposals cannot be taken forward through the Constitutional Commission. It does not mean that. There is no proposal here that would call for a person to renounce his or her citizenship. This proposal that we are referencing here relates to Turks and Caicos Islanders who have the citizenship called British Overseas Territories Citizenship, right? That is what we are talking about. Those persons, if they acquired another citizenship, automatically, without any choice of their own, would not be barred from running, from putting themselves forward. That is what this proposal does. If there are other proposals, if you're introducing in the conversation, other proposals, those can be taken forward There's nobody saying that they cannot, but they are not in this set of proposals. Because remember, what we've come here is to talk to you about the proposals where we started, we went all around and talked about them, and now we've come to say these are the ones that we have managed to agree across the table in the negotiation. But we said that we have also secured a provision for a constitutional commission that will be set up to look at the Constitution and to make further amendments. So I don't think anyone should feel that the door is closing and we wouldn't have an opportunity to consider other things. That's not the case.
I'm sorry to keep you to this dead horse, right? But my question is personal, okay? Because I'm really trying to understand what the current law states as well as what the proposals for the amendments, okay? Myself, personally, I am Turks Island by birth. I have Turks Caicos Island status, okay? I also have American status, okay, that was acquired through my father at a young age, okay? And what I'm trying to understand here is that if I wanted to put up my name to run to be an elected member, okay, do I have to renounce my United States citizenship in order to be able to run based on the current law and also on the proposed amendments to the Constitution?
Thank you. And so in relation to that question, as it stands now, the answer is yes. As it is proposed in here, the answer is no. Right? And so for persons like yourself, and you are not unique in that regard, there are plenty of Turks Islanders who are just like you. That is addressing the concern. Okay?
Everybody here now?
Maybe put some two really quick. Really quickly. This particular.
Okay, let's have one meeting.
This particular.
Honorable Mr. Bain, Honorable the last
This
speaker.
particular provision, I noticed in the process to the whole meeting, you mentioned about looking at different constitutions, the Cayman Islands, I think you brought up at some point you mentioned something from South Africa, right? How does this particular provision stack up with the Cayman Islands and Gibraltar? Is there any similarities, different, or is it the same? And the last thing, it might not be, I don't know if it's pertinent to this particular meeting, but the gentleman, I think they call him Jack, he mentioned, he mentioned something about Constitution and a person born here with a single parent gets a Turks Caicos Island law. I think you said to the contrary. Just to benefit of the student, can you please explain how that particular provision works? Because I would like to know myself. Thank you.
So, Honorable Nancy, as it relates to Turks and what we're talking about in this provision is citizenship. Turks and Caicos Island status is not citizenship. What we are talking about is citizenship in this provision. All right? So I think that's important to recognize. Turks and Caicos Islander status is a requirement to put your name forward, but that's not what this is talking about. This is talking about citizenship.
What's the difference?
All right? The difference is that the citizenship that we have is acquired under the British Nationality Act. We are British overseas territory citizens. There's American citizenship, there's Canadian citizenship, there's, right? No, Turks and Caicos Islands is not citizenship. But I'm conscious that some persons are going and we're at Article 7. So I want us to get through, you know. Yes.
Good night.
No, they say you would finish explaining.
Right, so what I'm saying is that this provision is talking about citizenship. So a person is under an oath of allegiance to a foreign state when they acquire the citizenship of that state. And so to Turks and Caicos Islander or not Turks and Caicos Islander is irrelevant to this provision, to this section. It is the citizenship that we have that is at play. So if you're a Bahamian, or if you are an American, or if you know, those are the things that we're talking about.
What does the Cayman Island Constitution say? Or Gibraltar? Because that's, you mentioned those two constitutions.
Right, so in relation to that, to this provision, the Cayman Islands Constitution is like our current Constitution. But the Cayman Islands does not have the same makeup of the Turks and Caicos Islanders that we do. Cayman Islanders, are not born in the U.S. and the Bahamas and so on at the frequency that we have here. So our Constitution still has to address the circumstances of the Turks and Caicos Islands, okay? But it's not Turks and Caicos Island status that we're talking about. There's nothing disturbed about Turks and Caicos Island status or the requirement for it by this draft order. Nothing. Okay? All right, let's move on, please.
Yes, good night. I think it should be a certain amount of question asked on one topic, because we won't continue this without finishing 9 o'clock tonight.
Yeah, so I agree with you. So let us move on. Article 8. So Article 8 says, autonomous and exclusive capacity of cabinet. Currently, the Constitution is silent on whether the domestic matters are devolved to the cabinet. Despite the practice, there is a need to expressly set out the more modern approach being taken in practice. And so this draft order clarifies that the Turks and Caicos Islands Cabinet has autonomous capacity with respect to domestic affairs. And it also, as a further proposal, sets out matters relating to external affairs that the governor must delegate to an elected member of the cabinet. So to break that down further, in terms of matters that relate to the domestic issues of the Turks and Caicos Islands, the UK has clarified in here that these are devolved from the UK. It's not a matter for the UK government. These are matters for the local government. And so as it relates to these things, the cabinet decides on it, and the Constitution says that the governor is required to take the advice of the cabinet, except if the advice is breaching the Constitution, contrary to the statement of governance principles, is instructed by a Secretary of State. In relation to having this provision, when you put what the governor can and cannot do against having this provision in it, and the Constitution, it means that the local elected government, the cabinet, is making decisions, and the UK has accepted that they are empowered to make those decisions without the UK government interfering, unless there is something like a breach of the Constitution, right? Something unlawful. So when the advice is given to the governor must take it in respect of domestic matters. It also further says that in relation to certain external affairs matters, and they're listed, and these would be the conduct of external affairs affecting the Turks and Caicos Islands within the Caribbean community, the Association of Caribbean States, the United Nations Economic Commission for Latin America and the Caribbean, or any other Caribbean regional organization or institution. Those are matters to be extended, to be delegated to an elected minister. All right? Other Caribbean regional affairs relating to specifically issues that are of interest to or affect the Turks and Caicos, those are for the minister. Tourism and tourism-related matters, those are for a minister. And any other matter related to external affairs as the governor sees fit. It's important to have these provisions there. They are in the Cayman Constitution, right? They are in the Gibraltar Constitution. These are in the more modern constitutions. They ought to be here because these are in practice what is happening. And so we need to have it reflected in the Constitution so that it doesn't depend on personality. It is written into the Constitution that these are within the responsibility or the purview of the cabinet. Any questions or comments on that?
Any questions or comments on that?
Madam AG, let me just jump in here. I think this is something very good to have. The old Constitution, section 37(2), it says the governor acting at his or her discretion may. Now the provisions will say the governor shall delegate these things. When we go to meetings in CARICOM, so we won't have the governor sitting there with the Prime Minister of the Bahamas and the Turks and Caicos Islands, and so we can have our own person there, our own premier representing us and not sitting behind any governor. So this is saying that the governor shall, and not the governor acting on his or her discretion.
So let's keep it moving. The establishment of Cabinet Office and Cabinet Secretary. So currently the office of Cabinet Secretary is not a constitutional position, and whilst there is the public office of Clerk to Cabinet, there is no office of Cabinet Secretary. And so this order proposes that the public office of Cabinet Office and Cabinet Secretary would be constitutionally established. And the Cabinet Secretary would head the Cabinet Office. The Cabinet Secretary would provide frank and politically neutral advice to the Governor, the Cabinet, and the Premier on matters of policy, would monitor and coordinate the implementation of policy between departments and ministerial portfolios and across the wider government sector, to ensure that government policy is developed coherently, and would provide for administrative and secretarial support for the Cabinet and the Premier in order to facilitate high quality and effective government, and would arrange the business for and keeping the minutes of the meetings of Cabinet or any Cabinet committee, and conveying the conclusions reached at the Cabinet to the appropriate person or authority, and such other functions as the Governor, acting after consultation with the Premier, may assign. Any questions about that?
Yeah, quick question, and I'll come to my next question.
And then there's one over here.
My question is, will there still be a public office of the clerk to the cabinet? Will that position still be there? Okay, thank you.
Yes, that position would still be there. Thank you.
Okay, my question is on the Cabinet Secretary. I want to know how is this appointment going to be dealt with. I don't know if this person is going to be an appointed position or a civil servant. Can somebody speak to that? First?
Yes, it's a public office, so it's a civil servant.
It's a civil servant that would actually be selected through the Public Service Commission.
Yes.
That's the body that's there, right?
Yes. The Cabinet Secretary would be selected through the Public Service Commission. That's the question.
Can I just add to that, Honorable Delancey, that was one of my concerns also, because I was wondering if, like with the Cayman Constitution, the cabinet secretary is appointed on the advice of the premier. So I was wondering, what is the difference here? Are we going to allow whoever's the premier to appoint their cabinet secretary to get their governance agenda done and follow up, or are we going to make it a public servant who will be there regardless of which premier coming out of power and out of power? So I do understand your concern. That is one of them that I had also in relation to the Cayman Constitution, where it's on the advice of the premier, where in our situation we are saying that it is a civil servant that will be there from time immemorial, regardless of which government is there, which premier is there.
Just for clarity, this position, the cabinet secretary, will they have to be a Turks Island?
There isn't a provision in this draft for that person to be a Turks Caicos Islander, but within the public service, the senior positions within that likely cadre are all designated for Turks and Caicos Islanders. So it would be odd for it not to be.
Can we add that to that?
I don't think we can for this. Well, because remember the details of the position can be, set by through the public service process. At this moment, it cannot be added to this, but it is something that can be taken forward as a new proposal. Or as I shouldn't say new, because there was discussion about it, as the leader of the opposition said. But it is something which could be furthered, right?
Good afternoon. I think we good afternoon. I just think we brushed over section Article 9. I didn't have the chance to bring up my concern. I just wanted clarification on the external affairs that are delegated to the governor. I see in section C that it says that tourism and tourism-related matters would be delegated to external affairs to the governor. I just wanted clarification on why tourism specifically would be under the governor, seeing as it's a sector that generates a lot of, the majority of the GDP of the country. I thought that this would be domestic affairs and not under the governor.
Right, so there was quite a lot of talking at that moment when we covered it, and so you may not have heard, but we did cover it. And this list of things that are there on page 12 of the explanatory guide, these are all things that would not be for the governor. These are all things that are related to matters of external affairs that would be for an elected minister. Right, so it's just clarifying this list here that without any shadow of a doubt, these are things that the governor must delegate.
Okay, so, yeah. Thank you for the clarification.
Thank you, Larissa. All right, so then let us move on. That is 9 and we did 10 as well. And so now moving on to Article 11, the establishment of the National Security Council. So as I said, there is already a National Security Council, but it is not established under the Constitution. As it previously was in the 2006 Constitution, and then it was removed in the 2011 Constitution. And it is existing in other modern OT constitutions. So therefore, it was proposed to be returned, and it has been agreed that the National Security Council would be a constitutionally established council and would carry on its functions as it is currently operating, but under the purview of the Constitution. It's there on page 14. Is there any comment?
So you're basically telling me that the National Security Council, as we know it now, is acting unconstitutional?
Yes.
Get time.
I say you basically just told me my understanding, that what we call the National Security Council at this moment is actually acting unconstitutionally.
No. So the National Security Council is established under an ordinance called the National Security Council Ordinance. But it is not. Yes. And
unconstitutional, it's not constitutional.
No, it's not unconstitutional. It is not in the Constitution. But it should be, because it is such an important body that it should be at that level in a modern constitution. All right. Any other? All right, moving on. Article 12, timing for dissolution of the Parliament. So currently the term of the House of Assembly is 4 years. But what this proposes is an extended term of 5 years. Is there any comment about this proposal?
Yes. Just before persons come in, this is one that I look at all the results from around the islands. And I can tell you, Solkey said they don't mind 5 years. They had consensus for 5 years. Middle Caicos consensus for 5 years. North Caicos consensus for 5 years. South Caicos reached no consensus. Grand Turks said 4 years. Providenciales said 4 years.
Okay. I was not at any of those other ones. I can let them talk. I will talk to you here.
I really don't understand, based on what you said, Honorable Ashley, that it doesn't seem as if the majority of people are in favor of this change in number of years for politicians. So why is it in this draft? I mean, the order, it's a draft. It ain't passed by, it hasn't passed by the UK Parliament. This ain't going here. Even if it passed here, it doesn't pass in the UK Parliament. So, if the majority of the people, Premier, 14-1, if the majority of the people do not want the term of years to be 5, why is it in this draft order? Why is it changed here? If you can't do nothing in 4 years, you need an additional 5 years, an additional year for. You can't do nothing in 4 years. 5 months ain't make that much of a difference. And the people don't want it. Why is it in this draft order?
Thank you very much. That too was expressed in North Caicos. They even said why you took the minority, which is Middle North and Solkey, and the majority, Grand Turk and Providenciales. Providenciales we had all the people. So this is one of the things that we do believe, I myself believe that it should remain at 4 years. That is what I think. Because like we say, if you can't, if you can do it in 4 years, then the people will give you the additional 4. But this is one of the things that we had to have consensus on 4 or 5 years, and so they came up with 5. But I personally, and most people who I talk to think that it should remain at 4 years. But you had 3 islands who said 5, and 1 didn't get any consensus. 2 islands, Providenciales and Grand Turks said 4. Solkey, Middle Caicos, and North Caicos said they don't mind the 5. And South Caicos and the town hall, they didn't reach a consensus on it.
Is it possible to provide, I guess,
I made one comment at the outset, okay, and it has to do with the same very matter. Okay, how do you determine what is the will of the people when you conduct your meetings? Right? If there are 100 persons here and a matter is brought forward, could you indicate by a show of hands how many are in favor? You could count them, right? Do you do that during your meetings? How do you know what the majority of the people want? Okay? But when it comes to Providenciales, okay? If you look at just seats, we got 10 seats, 10 constituencies, right? And we got six here. And the rest of the country got 4. So the majority of the people right in Provo, and the people in Provo say they wanted to remain 4. And plus you got another island renter, with the other, major population, they say 4. Stay with the 4. That's the majority. Now listen,
What I can say is that more people within the Middle Caicos have less people than the people within Provo. Right?
Listen, in 1995, okay, it was a 4-year term, right? We won the 4-year term. 1999, the people felt that we should get another term. They gave us a second term. 2003, they gave us a third term. If you do good by the people, they will return you either 10 years or 5 years or 4 years. Right? You do what the people want, the people will return you. That's all I gotta say.
Thank you. All right, so I once again reiterate the process that these proposals have gone through, and these proposals as they sit here were negotiated across the table by a delegation appointed by the PNP and a delegation appointed by the PDM, including with senior counsel for each of them. And these proposals that are reflected in this order were agreed at that meeting. I just want to once again reiterate that, so that, no, just a moment, right? I just want to be clear about that. That is important to be clear about. And also, I want to once again reiterate, because I don't vote in any place where I operate. So the people that vote are the people who are elected into those places. And what we have here is, in Turks Caicos Islands, is called representative government. And if persons stand up in the House of Assembly where the laws are made, and they say that they are speaking on behalf of their constituents, that is a serious matter. That is a serious matter. And so I think you should be aware. You should be aware of that. So,
hello, let's get order. Order back again.
Yes, Mr. Taylor.
Not when it comes to the Constitution. Jamal, 1 minute, please.
I wait until you come back, because I'm an honest and truthful person. I try to be. I cannot say I have never lied, but I try not to. In the one here in Providenciales, it was outright 4 years. And we did have a good crowd then, because that was one of the earlier things that came out before the people started leaving. I think we was here very late, very, very late. So what I'm trying to understand, you understand? Because everything else here that was discussed, most of that was discussed here, and it was on a positive light. Because you remember, even when it came out, when the situation came up, when the question was asked or put forward, I think with someone on the floor, about your position, that somebody said they think it should be an electable position. We voted against that. We said we didn't want your position to be an electable position. No, it shouldn't be, in my opinion, but hold on, I can give you the mic when I finish. But the term increase to 5 years was outright by everyone. Not one person I can recall endorsed that night. So what I'm trying to understand is that when you had the members that made up the panel that went after the lady and putting everything together and making a decision, I don't see how that could be put forward that Providenciales is the masses of the people's voice because of the population. That got included in this. I quite don't understand, because even if there were PDMs or PNPs on that panel, for them to put that forward, and they were politicians. Were they politicians or outsiders also?
You mean
non-politicians?
You mean in terms of the, tell me what you mean.
Okay. You said there was a firm that put this together to decide what to put forward to the UK.
Let me explain that, because it's really important. So when that Constitution Commission that went around the islands was finished with its work, it reported, it was appointed by the House, and it reported to the House. In respect of Providenciales, the Constitution Commission's report faithfully reported what the meeting said. And so there is no report that says Providenciales said, yes, 5 years and not 4.
Yeah, so I'm wondering what after that now.
Right, so let me just clarify that so you're clear on that. Remember that the report went back to the House on all of the proposals. The House then had a public debate in respect of all of these matters. What came out from the House were the proposals which informed this work. And the House voted for the 5 years instead of the 4. That then went, right, so that then was included in the proposals, which went to stakeholder consultation, which went to face-to-face negotiations.
Okay, that's fine.
Right.
But that's, I quite understand, because if I was a politician then too, because it's now up to the politician, I would say 5 years too, because I won't get paid for 5 years. No, serious. But that shouldn't be like that, because the people had already spoken on that matter, and the politicians shouldn't even be willing to put that particular one forward, because they know the people had already spoken on that particular matter, and that matter is only going to benefit the politicians. You don't know how Turks how we go. We vote in PDM, they get back, we want them gone. Next time, we vote in the PNPs, and we satisfied, we want them gone. So that would only benefit the politicians. But like you say, that was the process it took, and I quite understand.
That's the process that it took. Okay? All right, that is, yeah?
Well, in my submission, the will of the people have been trampled on. It should not have changed. You talk about representative government. This is, you're talking about a constitution that will impact all of our lives. And what the will of the people state, it should not have been changed further down the road when it came to the politicians who acted only their own self-interest. That's the way I see it.
Right, so
right?
thank you for
If there is a question in this order about not reflecting the will of the people, and I know it's when it comes to the term of years, it doesn't reflect the will of the people, I question everything else in this document. Everything. Because what was said in the consultation, how do we know that that was exactly what was transferred in whatever other stage of the processes?
So
yes, I question everything.
No, Ms. Bell. No, that is irresponsible. It's irresponsible because it's irresponsible, Ms. Bell. I'm not going to let you get away with that. Because the Constitution Review Commission reported. There is a document that recites the report of the Commission. That document was debated publicly in the House. And so it cannot be said loosely that we question what they reported and so on, because that is irresponsible. The report was publicly made available publicly, and it was debated publicly. And as responsible citizens, it is our duty to go and look and follow up and make sure that what was reported, don't come and then say here in this forum, you know, that I question everything, because I said it was faithfully reported in terms of what person said, right? So it's a public document. We have a duty to go and do our research as well. But also, in terms of these issues, remember there's a debate on the 17th of October, and each person in here has a representative. So you can speak to your representative about these things that you have a concern about. And then, no, you don't have just one. You have more than one. Because you have whoever represents you in the constituency where you live, and you have the 5 all-island elected. Yes, you do. Come on, good cousin. Because the fact of the matter is, these persons are, you let them get away when you say to them, you don't represent me. The blue people and the yellow people represent all the people.
You know, it just seems to me that it is convenient. People that make decisions have a way to have their way. And I really don't feel as though you're being not used. I don't feel like the persons that voted, they have that 5 years, that negotiated the 5 years. I just don't feel like it was exercising the will of the people. And to say that you had islands that had the least amount of people on them, you use that comparison and say, well, okay, four voted for it and 2 didn't vote for it, or whatever it was. I just think that's disingenuous, and it's not the will of the people. And I just would like some kind of commitment from the powers that be, that they will consider the atmosphere here tonight when they go to the House on the 17th. A sticking point for me is still this whole business of renouncing. I have a problem with the way that it is. I feel as though the general public didn't have a problem understanding of it, the way that you guys have it written in the document there. I think that is a sticking point. I feel as though before you guys go to the House and vote and say that this is the will of the people, consult the people again, okay, and make clear what it is that this whole renouncing business is about. Because I think most Turks and Caicos Islanders do not have the understanding of what it is.
Thank you for that opinion. I think it is important to recognize that, you know, everyone has their opinions. I think what we're hearing in the room tonight is at once, this is what the town hall meeting said. I don't agree with it. This is what the town hall meeting didn't say this. I agree with it. We're having a lot of opinions in here this evening. And it's a constitutional right to express, you know, your opinion, and that's what we're here for. You know, but I would also say that there is a debate on the 17th of October, and you have access to your representatives. Yes, sir.
I just have a quick question. You may or may not know off the top of your head. Compared to other Caribbean countries, how many have 5 and how many have 4? Is it majority of the region has switched over to 5, or is the majority of the region still doing 4? That's just a general question, nothing to do with if I agree with the actual decision, but just asking for us to know what our regional persons are doing as well.
Yes, thank you. So as relates to the independent countries, in the region, the majority of those countries have 5 years. I will have to check to see what that is, but I suspect it's 5. But the constitutions are available online.
Honorable Agent, I have a question, more than one, but I have, what is the amount of years in the UK? Is it 5 years? 5 years. So we went after the UK say. We are under the United Kingdom, but of course, the Great America, even we have 4 years. But however, I want to point out something here. I tried to get the Honorable Salmis to stay because he spoke after me and said that when going into smaller countries or less people to vote, less communities, smaller constituencies. Like for example, let's say, I said about Saltine. If Saltine has 6 people, he feels like those 6 people could be easily bought out.
Could I ask you to give me your patience? Let us close this issue and then move to the next, because that comes up in Article 13. So then you'll be the first one to speak in respect to Article 13. Okay. Is there anything else?
One quick one. So how many voters do we have? 9,000? Okay. If we are able to get signatories from 51% of the voting populations before, hold on, let me ask my question, what happened to you, Mr. Robinson? If we are able to get signatures, names or signatures for 51%, it's a question, of the voting population before the 17th, and send that in, would that make a difference from this 5 years getting changed to 4 years? Because I think the majority of everything else that is here, the public does not really have an issue with, they just needed clearer understanding. So that is just my question there.
It's not really a question for me to answer, but I would answer it in this way. You have elected persons to the House of Assembly. They are your representatives.
I'm just going to say, I have been on record with the 4 years, and I'll continue to be on record with the 4 years, but that is just one voice there. But I have been on record for the 4 years, and I like the 4 years.
You got to understand that the powers that be, politicians, the powers that be, want an extra 25% time. Okay? They're not interested in what the people ask for, and they have this as far as they're concerned. You get them 90%. The Turks Islands say they don't want 4 years, and they will still decide and go with that 5 years. And it doesn't matter. That's Saturday at mind. That's Saturday at brain. They're going to do it. Where the Turks Caicos Islands people say no, they're going to do it. And I don't care who don't like you saying this, but it's called greed with politicians. When you don't listen to the people. And at this point, I think that's one sticking point that you guys should listen to the people. And to come up here and just claim and say, well, it was debated in the House. Well, we know the old adage. The opposition will have to say, but the government of the day will always have its way. So we know who definitely supports this.
I want to say, let me say one thing.
Everybody is going to be able to stop because that's casting stone is fire.
Right, but let me say one thing because I don't want any misrepresentation, right? And I've said it a couple of times tonight, but I'm going to say it one more time. the proposals that are reflected in this document were agreed by the TCI delegation, which comprised of persons from the PNP and the PDM. Okay? So I'm not a politician, and so you can make it what you wish.
That had nothing to do with what you said.
No, yes it does. Because you talked about the House of Assembly.
Yes.
I'm talking about a bipartisan negotiation across the table with two parties representing the
My
TCI.
statement is this on the page.
Is that was the will of the leading political party, and regardless to the people saying, I know you can go back to the study and the advisors and all that, and I understand all that. My statement is nothing really on you, so don't take it personally.
No, I'm not taking it personally. I just want to be factual.
The political powers that be, because you don't have anything to gain from this provision. So I'm speaking about the political will. If they want to really exercise the will of the people, they would stop with the 4 years and not push the 5 years when they know that the people don't want 5 years. That's what I'm saying. It's nothing to do with you and any statement you made on the page. So please don't take it that way.
Yes.
Good idea. So once this constitution here is passed, we will now have the option to have a referendum moving forward, correct?
We haven't reached did we reach referendum?
No.
We haven't reached the referendum this year.
No. I'm saying, but once this constitution is passed, we will have that option for a referendum to be held.
Yes.
So,
yes, that's right, it is.
can I suggest, we are never going to come to an agreement on this 4 or 5 years tonight or tomorrow or next month. So when this constitution will cross, the first set of folks that win will have the 5 years, but during this same election period coming up, or however referendum rules will be laid out of when it can happen, can we just hold a referendum on this particular thing? And okay, the first set coming through can have 5 years, and then we hold a referendum. If the people vote to change it back before, then we change it back before. It's a question.
Basically, the whole background to the constitutional amendments is the modernization of the Constitution. Parliaments worldwide are 5 years. Every parliament in the Caribbean, every overseas territory, House of Assembly have a 5-year term. Every one of them. Go check it for yourself. Okay? The whole background is to modernize, to move towards parliamentary practice in terms of planning cycles. Planning cycles are 5 years, right? And you can't have it both ways. You said in terms of electoral districts, Middle Caicos should have a seat, and Salt Key should have a seat. So if numbers, if you're going to focus on individual island representation, you can't in one breath say it don't matter how many people in that constituency, they still deserve to be represented. And then you come to Provo, now you change your whole argument, you're undermining your own argument.
Sir.
Well, that's what the leader of the said. And at the end of the day, we sat around a table, and regardless of what our individual positions might have been, we sat around a table and collectively as a team, we arrived at this document. So to be quite honest with you, I find it disingenuous on the part of the leader of the opposition now to want to walk away from this. I mean, huh? What?
Sir.
What's that? No, I'm not attacking him. I'm saying we arrived at this.
Sir.
He doesn't agree with everything.
He didn't do it first, and then after that he agreed.
It's consensus, it's consensus.
So we're going to move on from this item. No. Okay. No, ma'am, we're going to move on. Now, wait a minute. To electoral district boundary commission, which is Article 13. In respect of the composition. I discussion. No, we have beat this item to death. We have been on it for a long time. You see the room is emptying out. I want to get through the proposals. I've given you the options of what you can do in relation to the issue. So, okay, but can I say something? No, ma'am, we're moving on. Can I say one thing? Say one thing, and then let us please move on. Right. It's clear to me that this amendment of our Constitution, this amended order, draft amended order, is not the will of the people. I would recommend to everyone to write into the UK and the Foreign Office and Commonwealth, whatever development office, and state your case. Because the will of the people, coming from the people, is not lost along the way, on its way to England. Okay, thank you, Ms. Bell. And moving on now to Article 13.
Yeah, she should close this down, because this will make...
Yeah, because I told you about an hour ago, you could write to the UK. Composition and powers of electoral district boundary commission. Article 13. Currently, the governor is empowered to appoint 2 members of the electoral district boundary commission in her discretion, one of whom must be a person who holds or have held high judicial office, and one other after consultation with both the Premier and the Leader of the Opposition. The proposed order would allow the Governor to appoint the Chair of the Commission in her discretion from amongst persons who hold or have held high judicial office, or lawyers of at least 10 years standing, and 2 other members, each after consultation with the Premier and the Leader of the Opposition. This brings it back more closely aligned to the 2006 formulation of the Electoral District Boundary Commission. And also, currently the Commission can only consider the boundaries of the 10 electoral districts, the boundaries of them. What is proposed in this order is to empower the Governor, acting in his or her discretion, to appoint a commission and ask that commission to consider not only the boundaries, but the number of electoral districts as set out in the Constitution. Remember, there are 10 electoral districts, and this provision would allow for the Commission to consider the number of electoral districts and to submit a report to the Governor and the Parliament, a statement to the Governor and the Parliament in writing, stating that, in the opinion of the Commission, no change should be made to those numbers or recommending change to those numbers. And in this regard, they are required to also consider the number of elected members in the House. So it is possible, harping back to what the Leader of the Opposition said earlier, for an electoral district boundary commission to look at the 10 electoral districts and decide that there should be 13 or 15 of them. And in that regard, it would reduce the number of all island elected members and would increase the number of constituencies. Could I have any comments? Do you have any comments?
Yes, right here.
Before you go, just a clarification here. It says that the Governor appointed those members, both the Premier and I have to agree with it. So it's not that he appoints a member and I appoint a member. They'll bring us a name and say, do you and the Premier agree with this person? So right now it works, and we can find common goal and people. But it might be a situation later on that a premier or leader of opposition will not agree with those persons that is proposed. One or the other may not agree. So these issues can arise in the future. And I'm happy that this is not cabinet. I can give my opinion on or what my position is on things. So in cabinet, I can't come out as collective responsibility. But nobody said this is collective responsibility. So when I won 4 years or something against it, I can say I was against it. It's not collective responsibility, even though we had consensus and the final document passed the cabinet, and we know what happened in the House of Assembly and voted. So, but this, I'm just concerned about that, even though again, we agreed for it to let it be advanced, but this is a concern of mine. When the premier and the leader of the opposition cannot agree on someone, what will happen then?
Let me just clarify that again, because I thought we were on the same page, but it appears we may not be. So I want people to understand clearly. As it stands now in the Constitution, the governor can appoint 2 of the 3. The 3rd member, the governor consults with the premier and the leader of the opposition. As it stands in the draft order, the governor appoints 1. 1 is appointed by the governor after consultation with the premier. The 3rd is appointed by the governor after consultation with the leader of the opposition. So 1, 2, 3, governor, premier, leader of the opposition. That is returning the provisions more closely akin to what was in the 2006 Constitution, and it ensures that there's no need for agreement about the appointment. And that was what was agreed by the parties in the negotiation.
So that's what I'm saying. That is the mischief that it cures. Now, if this is passed and move forward in the Privy Council.
Just a question.
Just for clarification, I understand the 1 person appointed by the governor. The other two, the consultation, 1 with the lead opposition, 1 with the premier. Are those persons put forward, those names are put forward by the lead opposition and the premier?
Yes.
Okay, that's all I wanted to clear.
The other thing is, in respect of the chair, the governor appoints, it's the judge or a lawyer of 10 years standing. So it's a person who has experience in adjudicating, etc.
Okay, my question is, when it comes to the boundary commission, and they're looking to do new lines, separation, adding boundaries, that would have to take place after we do a survey, there's a question line, a survey with population registration, right?
So the Constitution currently sets out a process under sections 60 and 61 for how the Electoral District Boundary Commission arrives at its recommendations. In doing that, they do get information from statistics, they get information from survey and mapping, they get information from, everywhere that they can, so that they can make a determination.
Now, my question would pertain to, since we're going to be trying to even out the numbers, adding constituency not just by the size of that constituency, by trying to even out the numbers per se. That's my question.
Yes, so the provisions in relation to how what the Electoral District Boundary Commission has to do, which is the balance of the numbers as between the constituencies, is not disturbed by this. So they still have to look for that balance as a part of the work that they're doing. So this here doesn't make any change to that. It just gives them a wider purview. So instead of just looking for that balance amongst the 10, they can look for it amongst all the elected members in the House.
No, I'm not talking about the elected members. I'm talking about if we have 10 constituencies now, and they say, okay, we're going to add to the All Island, to constitution, and we're going to put them in Provo, that before I'm just using an example to say Providenciales. I'm asking the question is, before the Boundaries Commission started to draw the lines, to say, okay, this place big or this place big. They would have, I'm asking you, if they would do a survey or a census, whatever you want to call it, relating to registration of the individuals, the population, to try and get the numbers, because you could have this area here with as per the census, if you're using the census, a lot of census don't ask if you're a Turks and Caicos Islander and if you can vote. I have done the census for almost 20 years, and the question was never there to say, are you a voter? Can you vote? So that's why I'm asking that question.
Right. So they, I mean, I suppose they could do that, but they don't do that. What they do is they get the register of electors from the supervisor. So the work, so this was a part of the discussion as to why there needed to be sufficient time for the Electoral District Boundary Commission to do their work. Because in the election cycle, it is only after the 31st of March of every year that you have the register, right? The completed register. You have the list, you have the claims and objections process, you have the adjudication, you have the register. And so when you take that into account, because that is such important information, vital information for a boundary commission to have, they can't do the work without it. They have to begin there. So in relation to this process, that is the starting point, the register, so that they can understand where the voters are. Any other comment about this item? Okay. So this is an important modernization and advancement. And I did promise my good cousin that I was going to get back to her comment. And so in relation to that, because the Electoral District Boundary Commission has this widened function, it means then that in terms of the 9 all-island members, that those are only there for the next term. Because during the currency of that term, the Electoral District Boundary Commission has this important work to do, so that before the next election, the succeeding election, we have a framework which includes, perhaps, most likely, an expanded number of electoral districts. Certainly. Yes, because it was always agreed that that needed to happen. There's no disagreement amongst anyone that I'm aware of that that needed to happen. The only question was there sufficient time to do it properly in a way that people would feel that this was well done, transparent, and so on, or whether it was rushed. And there was agreement across the line that it should not be rushed, and so on. Is that correct, Honorable Leader?
Yes, sir.